Is now starting. All attendees are in listen-only mode.
To get people are still coming on, and then we'll get started. For those of you just coming on, I'm giving it another minute or two as people or attendees are still coming on, and then we'll get started. Well, thank you everybody for joining today. My name's Amy O'Hara, and I'm a partner here at Littman Krooks. And today I'm presenting a webinar on advanced directives, what they are and why you need them. You will have the ability, I should mention, to ask me questions in the chat box. I won't be able to look at them until the end of the webinar. The webinar should be about a half an hour or so. And I'll be able to answer them at the end. I just won't be able to look at them during the course of the presentation. So meeting with clients regularly to talk about their estate planning, there's often, when we start the dialogue and the new representation, there's confusion over advanced directives. Or sometimes clients will think that they have appropriate documents in place when they start a new relationship with us, and they don't. So the purpose of today's webinar is educational, and it is to just set down a foundation of what these documents are, how they could help you, and really why they're important. Advanced care planning affords you the opportunity to plan for your medical future, your financial future, in case you're unable to make your own decisions. And it's serious, to think about this in terms of having the conversations. It's not pleasant to think about. It's not pleasant to discuss with your family, but it's critical, especially in terms of emergency. So when I'm talking about planning for incapacity, I'm talking about advanced directives. And what the documents I'm going to cover today are power of attorney and statutory gift rider, as well as various healthcare directives, psychiatric directive I'll touch upon, and appointment of agent to control disposition of remains, which is not necessarily a document that's in place during your lifetime, but we still refer to as an advanced directive, digital assets directive, and I'm going to touch upon a revocable trust and guardianship. So power of attorney. A power of attorney is a document that sets forth where you designate an agent to make decisions, financial decisions, to act on your behalf when you're unable to do so. The document is a very powerful document, and in New York State, we have a template that we follow that's readily accessible and available and accepted by financial institutions. Since 2009, the agent, under new powers of attorney that have been executed since August 2009, the agent must also sign this power of attorney in order for it to be effective. If the power of attorney was executed prior to 2009, the agent's signature was not required, and it's grandfathered in. In this document, you designate at least one agent to assist. It goes into effect now that, as I mentioned, that the agent has to sign now when you prepare the document and sign it, and it goes into effect right away. The idea, though, oftentimes is people are, they feel that they're giving a lot of authority or a lot of they're granting these rights to an agent, and it's a powerful document. So education and just understanding that you keep this document, you let the agent know that you've designated them, they sign it, they give it back to you, and you let them know where you keep the document, the original document. You do not need to necessarily give them a copy now. You obviously want to trust, and the people that you're designating the most, they're put into a powerful role because they could have access to all of your financial accounts. They could pay your bills, they could move your money around, they could transfer property. So they have a fiduciary responsibility to you in acting. The power of attorney will grant them the authority to make various banking decisions, transactions on your behalf. They could transfer real estate. Important in our practice is they could do Medicaid planning, asset protection, to move assets around, and have granted broad authority to handle various transactions on your behalf. All powers of attorney are drafted in New York, or most of them are. In fact, our New York form is drafted as if it's durable. It's a durable power of attorney, meaning it survives any type of incapacity. So and that's really where you want this document in place, is that it becomes really important if you suffer an incapacity. We have the ability to do a springing power of attorney, but it's typically not recommended. And what a springing power of attorney is it only goes into effect when you become incapacitated. But in order for that power of attorney to spring into effect, your agent must get certification from a couple doctors to certify your incapacity. And in our experience, many doctors do not want to sign off on incapacity for fear that the agent's going to make some type of mistake or negligence and be liable. In New York, we have the ability to grant modifications under a power of attorney, which really gives us the ability to make broad ability for the agents to broad powers to be able to do various planning on your behalf. And I always explain to clients that I really, because you're designating the person that you trust the most, so you want to really grant them full authority under the power of attorney, because when it becomes time to act, we never know what powers they may or may not need. And it's typical that they may only need 5% of the powers, but we don't know which ones are the 5%. So I recommend that you grant full gift giving power. Who should be your agent? Okay, very important discussion with your family and with your attorney. Oftentimes it's your close family members. It could be your spouse, another loved one, your children. Do you have more than one agent act? We try to think generationally. So if you have your spouse and you're older and your spouse is older, then who's that next generation that could come in and act on your behalf if your primary agent is no longer capable? Also, you could designate 2 agents or 3 agents. Typically, we don't recommend too many agents because it becomes cumbersome, and financial institutions typically don't care for that either. So 2 is commonplace, 1 or 2 agents acting at any given time. When you have more than one agent act, you could grant them the authority to act separately from each other, as opposed to acting that they have to do every transaction together. And we have found recently, over the last couple of years, that various financial institutions, banks, such as, for example, Chase or Citibank, are not honoring powers of attorney where it requires agents to act jointly, because they fear that one agent may take an action without the consent of the other agent, and that at some point the bank may be liable for that. So we typically recommend that the agents have the ability to act separately. It also makes it easier, I find, in family situations, because if it's the children acting or your siblings are acting on your behalf, they divvy up the roles and the responsibilities. One agent may handle certain transactions, another agent may handle other transactions. Since 2009, on our power of attorney template, you have the ability to grant compensation to your agent. Clients don't often do that. I find it more often for clients who may not have appropriate family members to designate, and they're asking friend or somebody extended outside their immediate family to help, and they want to give them some token of appreciation, compensation for the work that they may or may not have to do. Also, you have the ability to designate a monitor. And I haven't, since 2009, I haven't had too many clients that have done this. I have found that it's more in business transactions where an individual may be appointing his or her attorney to act for a closing, for a real estate closing, and you're designating somebody to monitor that. Not too often where I've had that situation. It's important. I always counsel clients when we're dealing with powers of attorney to not wait to an emergency to kind of put this power of attorney in motion. This is generally for my older clients, not necessarily my middle-aged clients, but I will say, you know what, let's put this power of attorney on file with your bank. Let's get it through their legal department so that they have it there. It's ready at some point when it's necessary to act. Because it usually takes the financial institution, meaning the banks, such as Chase, TD Bank, Citibank, a couple weeks for the power of attorney to work its way through their legal department and for them to accept it. Where if we're dealing in an emergency situation and we don't have immediate access, it certainly causes a lot of stress on the family. For my clients who are snowbirds, I typically recommend, and they may have a bank accounts here in New York, and they may have bank accounts in Arizona or Florida, go ahead and sign a second power of attorney. Sign one particular to that state so that it's accepted in that state. You just want to be careful that you don't unintentionally revoke a power of attorney in another state, or so it's important to coordinate all of this with your attorney, and if you have multiple attorneys, that your attorneys work together on that. Coordination is key. Okay, so in 2009, when New York State completely revamped their power of attorney law, and they did so because there were certain abuses by agents in not fulfilling their fiduciary duty and using money maybe for their own benefit, or making certain transactions that was not in the principle, meaning your best interest, that New York State really tried to revamp their power of attorney. And in doing so, they made certain things more complicated. And now, in order for your agent to have the ability to make gifts on your behalf, you have to execute a statutory gift writer. And if you don't execute the statutory gift writer, your agent is prohibited from making any transfer or gifts of your assets in excess of $500 a year. And when we talk about gift, yes, it could be your typical, holiday gift or birthday gift, but where it is more critical in terms of where we come in as elder care attorneys or estate planning attorneys is to be able to do that advanced estate planning, whether it's you're going into a nursing home or need some type of long-term care, and we want to try to protect assets, and we may want to do some type of Medicaid planning. If we're dealing with any type of estate tax planning, and and we want to try to move money around or make gifts to minimize any tax exposure at your death, it's important to have this ability, if you're incapacitated, that your agent has this ability to be able to make these transfers, meaning gifts, on your behalf. And in this rider, you get to designate, or you get to detail what type of gifts or transactions can transpire, what type, who can be the recipient of those gifts. Can the agent make gifts to himself if it's a close family member? Is the agent limited to making gifts only as you anticipate through your will? So all of these are important decisions and discussions that you should have. So now I'm going to move on to healthcare decision making, and there's several different advanced directives that we use in our office or that we recommend for clients. And so I'm really going to cover these that are listed here: healthcare proxy, living will, a HIPAA, a DNR, the most form, And then if you don't have any of these, what New York State law says, which is that Family Healthcare Decisions Act. I'm going to cover the healthcare proxy and living will first, and then come back to the other documents after I cover them. So in New York, we have a New York healthcare proxy law, which allows you to appoint someone that you trust, such as a family member or a close friend, to make healthcare decisions for you if you lose the ability to make those decisions yourself. By appointing a healthcare agent, or sometimes referred to as a proxy, but it's an agent, you can make sure that your healthcare providers follow your wishes. The doctors, the emergency room, hospitals, your agent can decide how your wishes apply as your medical condition changes. And hospitals and doctors must follow your agent's decisions. New York State has a standard template that we follow that's accepted by all the hospitals and doctors. And when you do sign a healthcare proxy, I recommend that this document be filed and provided to any medical providers, that they put it on file with your medical records. Any doctors that you see regularly, put it placed there. You could even consider carrying a wallet card. I know our office prepares them for clients when we do our estate planning. You know, and it's a little miniature version of the healthcare proxy. Typically, we only have the ability to designate one person on there. And this is a document you could just easily hand out. You can make copies of, and put it in various, with various doctors. Who should be your agent? It really requires thought and who you're selecting, because this agent is going to be responsible for and have the responsibility for making decisions that you would want, not what they would have wanted. So they have to, what we have in New York is what's referred to as a substituted judgment standard. We have to substitute, they have to substitute their own judgment for what you want, okay? And if that is not known, then they have to follow a best interest standard. What's in your best interest? So that being said, it's very important that you discuss with your agent what your wishes are. Have a family meeting, and talk about this, even if it involves other people other than who you're designating as your healthcare agent. Before, I mentioned with the power of attorney that you have the ability to designate more than one person to act on your behalf, where you could have multiple agents. Well, with a healthcare proxy, you only designate one agent at a time. And that agent, if that agent's not available or unwilling to act, then you would designate a successor agent. So it's always good with any of these documents that I'm talking about today that you have that successor agent designated. And what I mean here by second marriage issues, because we encounter this from time to time in our practice, in that whether it's the step parent that's designated as the healthcare agent, or it's the child, they're inevitably sometimes results in this conflict and this stress between the children from a prior relationship and this step parent. And that's I can't emphasize enough how you just sit down and you talk with your family about what your wishes are and why you're designating the people that you're designating. Sometimes I have families or people that won't designate their spouse, even if it's a first marriage, but because they feel that their spouse is not going to honor what their wishes are, and sometimes that means ending life support, and they feel that their spouse won't be able to make those difficult decisions. So careful thought really needs to go into this. Living will. So in New York, our living will is a separate document from your healthcare proxy. It does not designate your healthcare agent. That's what a healthcare proxy document does. So a living will allows you to leave written instructions to your healthcare agent regarding your wishes, including end-of-life care. What are your wishes should you be in a terminal situation and there's no expectation of recovery. And this document, unlike a healthcare proxy, which is a standard form and we don't have a lot of opportunity to make changes on that document, a living will can really be a personal testament to you as to what your wishes are. And sometimes I will work with the client where the client may create their own living will, and I'll conform it to make sure it complies with New York law, because as you will see, even though we don't have a New York State statute, our highest court in New York, the Court of Appeals, has ruled that living wills are valid as long as they provide clear and convincing evidence of your wishes. So it must be clearly stated, and it must not be confusing. On this living will, oftentimes you'll have the opportunity, you have the ability to designate whether you want nutrition and hydration, if you're in a situation of end-of-life care, antibiotics, pain relief, and you could set forth any instructions on organ donation. You could also designate organ donation on your healthcare proxy as well. So it's important to really give this some thought. And I actually have some, I have some clients from religious perspectives that they will not sign living wills. I have other clients that just don't feel comfortable signing living wills, and that's fine. What's critical is that healthcare proxy, because that's the document where you get to choose who's going to make medical decisions on your behalf if you're not able to do so. So I'm going to go back and just spend a couple minutes on these other documents. So the HIPAA is the Health Insurance Portability and Accountability Act. And knowingly or not, you often grant HIPAA releases when you go to the doctor and they shove this form, that the office shoves this form in your face before you have the chance to see your doctor. And that basically gives your doctor's office the ability to communicate with your insurance company to make sure that payment can be processed. So HIPAA is very broad and far-reaching, but it also comes down to granting your healthcare agent the authority to access your medical records in order to make informed medical decisions. Similarly, a HIPAA release also grants your agent under a power of attorney the authority to communicate with your health insurance company and Medicare to coordinate the process payment of your medical invoices, or to dispute or appeal a medical invoice that was an appropriate service or charge. So the HIPAA will cover really all aspects of anything related to medical records, medical decision making, medical billing, and insurance needs. So in New York, and this is, let me start. So a DNR, do not resuscitate order. Your living will and your healthcare proxy do not, just by signing those documents, does not create a DNR order. And that's a common misconception, because a DNR is a medical order written by a doctor and instructs healthcare providers not to perform CPR or other life-saving emergency procedures if your heartbeat or breathing stops. So it is a document that is arranged with your doctor or other healthcare provider. Also, so your healthcare proxy actually has the authority, if you don't have the capacity, to enter a DNR on your behalf if you don't have the ability to do so on your own, if you lack the capacity. But just by designating healthcare proxy does not mean that you automatically have a healthcare proxy or a DNR. MOLST is another document that is executed and completed with your doctor. And it's a medical orders of life-sustaining treatment. And this form allows doctors to record your preferences regarding CPR, mechanical intervention, or other life-saving treatments on this physician order. And it must, under New York law, it must be completed by a healthcare professional and signed by a licensed physician. It's important that, and I think the idea is that this MOLST form, and typically it's done in a situation where there is some critical illness or progressive illness, it's not typically somebody that, who is healthy that we would enter into this MOLST form. It's, later in life or at such stage as you have some type of illness there's no expectation of recovery. And it's not intended to replace your healthcare proxy or your living will. It's the idea to support those documents, and it centralizes your end-of-life wishes. So let's say we don't have a healthcare proxy in place, and what happens if you suffer a medical emergency? Well, in New York, several years ago, the Family Health Care Decisions Act was created. It actually was created in 2010. And it sets forth individuals who have authority to make medical decisions on your behalf if you become incapacitated and you do not have a healthcare proxy, which is not good, okay? Because it may not be the individual that you may want to make your healthcare decisions, and they may not honor what your wishes would have been. Although under the law, they're supposed to, again, honor what your wishes are if they were ever made known or what is in your best interest. So New York state law says that if you do not have or designated an agent under a healthcare proxy to make medical decisions for you, then the following individuals have the priority. And first, it's a Article 81 guardian, if there was a guardian appointed on your behalf. And if not, typically not, there's a spouse or a domestic partner, if a domestic partner is registered, an adult child, and it doesn't clarify which adult child, so that could cause tension if your children do not agree on that. A parent, then a sibling, and then last is a close friend. So this is, again, last resort if you have not set forth a healthcare proxy. Okay, moving on just for a psychiatric advance directive. This is becoming an increasing important part of our practice, helping family members who have mental health disabilities or they have loved ones with mental health disabilities. I'm not going to spend too much time on this, and we have no set statutory document in New York, but these advance directives are becoming increasingly popular, and it's a written document that describes how you want your mental health care to be given if it at some point is determined you're unable to tell your healthcare or your provider yourself. This psychiatric advance directive can let others know what treatments, including medications, you want or don't want from psychiatrists or other mental health professionals, if there's certain hospitals that you prefer, and you could designate somebody who could help you on this behalf to make these certain decisions. And this document is not ideal for everybody, but it really is ideal for anyone who lives with or suffers from any type of mental health disabilities. So moving on from non-healthcare decisions is in our estate planning world now, we have this, given everything's digital now, we actually have a lot of digital assets. And if somebody suffers incapacity or death, and today we're not talking about, what happens at death, but really during your lifetime, you actually have the ability to create this directive called an authorization and consent for release of electronically stored information. What do I mean by that? It could be your emails, social media accounts, music, your photos, think of like your cloud, everything that's up in the cloud, financial accounts and statements. And it could be some of these documents that you grant an agent, the authority to access, or you could limit it. It doesn't have to be, follow everything. But you're still at the mercy of the particular system or service and their terms of service, that contract that you just kind of scroll through if you read or you don't read, and then you check the box because you just want to get through at the bottom, and you are signing, certain rights away that you probably don't realize, such as that if you ever had a disagreement, arbitration is only in the state of California, and various things. But even with this document, it's not an end-all be-all. It doesn't cover everything. And really the best recommendation I can have with dealing with any type of digital assets on any of those that you may want your family or agents to have access to is write down your usernames and passwords. You don't have to give them to anybody, but it's like my mom, she keeps a little book in pencil because it changes from time to time, and she'll update, and it's a book that's called My Passwords. And and I know where it's located, and if I ever needed to access it, I know where to get it. And she's actually very good about updating it from time to time if necessary. So that's really your best course recommendation, even though I'm talking about advanced directives today. Write down your usernames and passwords. Revocable trust. Now, a revocable trust is really not your traditional advanced directives. While a revocable trust helps with avoiding probate for any assets that are properly titled in the trust and provides for a disposition of these assets at your death, it actually also provides for ongoing management of these assets if you suffer any type of incapacity. And this is really important in that it works hand in hand with your power of attorney. And I have found it throughout the years of working with clients, if somebody suffers any type of incapacity and the agent tries to go and put that power of attorney on file with the bank because they didn't do it before, the financial institution, it's a lot of stress and a lot of back and forth. Whereas a revocable trust, if the assets are already titled into this trust and you become incapacitated, whoever you have as a successor trustee, just steps into your shoes, and there's really no questions asked. There's a couple pieces of paper that have to be completed for the new trustee to take over, but it just makes it much easier to deal with these various financial institutions in terms of this revocable trust. I will probably be doing another webinar at some point or presentation about the advantages of revocable trust, not today's purpose. But I will also say with revocable trust, you have the ability to designate a corporate trustee, whereas you don't on a power of attorney. And I have, many times throughout the year, I'll work with clients who actually don't have anybody to designate as their agent under a power of attorney, or they don't have a spouse or a child or next of kin. They don't have anybody in that circle of theirs that they could trust. And so they look towards a corporate trustee, a financial institution to help, but financial institutions are pretty much, for the most part, prohibited from acting under a power of attorney, but they can act in a revocable trust as a trustee. So that helps a lot and is a tremendous benefit for those individuals. So advanced directives. Couple points here that I want to make. They're not just for elderly individuals or chronically ill individuals. Any adult who's 18 years or older should have advanced directives. If it's provided they don't have any type of mental incapacity where we would maybe need to go through a guardianship. College students, for example, your child goes off to college and there's an emergency, and if you don't have a healthcare proxy, it's very possible that the emergency room will not want to communicate with you, or that the registrar or the the college will want to communicate with you from certain respects. If there's ever an accident for a young adult and you're not designated as power of attorney or healthcare proxy, yes, we have the Family Healthcare Decisions Act, but you don't have the ability to pay bills or do financial transactions, and it's not as good as having that healthcare proxy. It's critical for everybody and anybody who's 18 or over to really have these documents. You should review and update your advanced directives. I say at least every 10 years, and such time as you have any major changes in your life, you have a death of a loved one, you have children that become of age and you want to designate them. you want to actually, and law changes, you know, like I said, you know, even though in New York we had, we have the new power of attorney law that came out now, you know, many years ago, 11 years ago, and the prior powers of attorney are grandfathered in. As time progresses, banks are losing sight of what, excuse me, those older versions look like. And it's just better to have that updated from time to time, to have, you know, the latest and greatest templates. Do you have at least one backup agent? Because what if you only have one person designated and something happens to that person or they refuse to act? What if you move to another state? You know, that happens regularly where I have clients that move out of state. And I always recommend meet with an attorney in that state. I could give you a referral because advanced directives are typically state specific. Now they should be honored in the state that you move to, but it doesn't hurt to have them updated. Lastly, as I keep saying throughout this, make your wishes known to your agents. Let them know that you executed these documents. Ask their permission that it's okay that you're designating them, because you know, if you didn't have that conversation with them and then they get the shock of, oh, they're in this role, you know, and they never wanted it, you're in, you know, some problems there. And that leads me to my next slide, failing to plan. You know, that old adage, you know, failing to plan is planning to fail. Well, what happens if you become incapacitated and you do not have power of attorney in healthcare proxy? Okay, we're going to get to that. What happens if your agents die, refuse to serve, or become incapacitated themselves? What if your agents disagree? Or what if your documents are not broad enough to cover a particular situation? Well, sometimes, as a last resort, we have to go through guardianship in New York, which is not fun. And it's not what anybody ever intends or wants. And it's when you have the inability to provide for your own personal or financial management with no or insufficient supports in place, including advanced directives. In New York, for individuals who do not have developmental disabilities and the onset of the disability was post age 22, we typically are looking at our Supreme Court, which is our lower trial court in Article 81 proceeding. And the court appoints a guardian on your behalf to make decisions regarding your health care. It's called a personal needs guardian, and your financial assets, which deals with your property. And you typically do not have a choice on who's going to be appointed your guardian. Or you have limited choice because you have limited capacity. And so you lose control over who you get to designate. It may be somebody that you never wanted. It could be a stranger. It's extremely costly. You not only, your estate typically has to, or your assets have to pay for the person who's bringing the guardianship on your behalf, their lawyers, but the court may appoint a lawyer to represent you during this proceeding, and then the court has their own lawyer called a court evaluator that does the investigation on behalf of the court. So it's not uncommon for the person who needs a guardianship for them to be responsible, out of their control, to pay 3 different lawyers' fees. It's very intrusive. All your financial information is exposed into the court and to whoever's involved in the proceeding. And you know, it's costly. So it's important, again, to review these advanced directives, make sure you have them, make sure they're up to date, make sure you have agents that are willing to act and they understand your wishes. We also have one other advanced directive in New York where you could actually nominate your guardian. So as part, and this is part of what we do for clients when we do their advanced directives, we also do a nomination of guardian form. And that sets forth your wishes. That's where you get to choose if there was ever a guardianship proceeding commenced against you, or that your power of attorney or your healthcare directive was not broad enough and there was a need to commence a guardianship proceeding. It's telling the court who you want to be your guardian. Appointment of agent to control disposition of remains. This document is at your death that really goes into effect, and you appoint a person who has the right to control your remains at your death. You make your specific wishes known regarding the disposition of your remains. If you have prepaid your funeral, you would designate that information on there and what funeral home it is. And if you don't have this document, then New York State law provides, again, similar to the Healthcare Decisions Act, a prioritized list of individuals who have this authority to make these decisions. And I could tell you a few times throughout my career, this document has been critical in when there's family discord, and different family members have different thoughts and understandings of what dad wanted or mom wanted or their spouse wanted in terms of the disposition of the remains. And this document takes priority over what all of those, what they think mom and dad or my spouse wanted, ideas. So this is a very powerful document. It's an important document, and it's taking out some stress as well, assuming if there is no family discord. It takes out the stress of your family not knowing what you wanted, at your death. And I think that's it. So thank you very much for joining me today. I don't see that we have any questions. I'll just give it a minute in case there's any questions that come up. And otherwise, I appreciate you joining me today.